All right, let's get straight into it. Today, we're tackling one of those core concepts you absolutely have to nail for your law exams, the doctrine of privity of contract, specifically looking at it through the lens of the Indian Contract Act of 1872. This is going to be a quick, focused explainer to get you exam ready.
So, here's our roadmap. We'll kick things off with a basic doctrine, what it is and why it matters. Then we'll get into the really juicy part, how Indian law takes a different path from English law. We'll bring it to life with a couple of landmark cases, then cover the all-important exceptions to the rule. And finally, we'll wrap it all up with a super tight summary designed to help you crush it in your exams. Let's go.
Okay, so first things first, let's lay down the foundational rule. What are we even talking about when we say privity?
At its heart, the doctrine of privity of contract is actually pretty simple. It means only the people who are actual parties to an agreement can sue or be sued because of it. If you're an outsider, a stranger to the contract, you have no rights or obligations under it. The old Latin maxim for this is res inter alios acta, which basically means a thing done between others doesn't affect others. Think of it like this: a contract is a private club. If you're not a member, you can't use the facilities.
Now this is where it gets really interesting. And honestly, this is a classic exam question, so you'll want to pay close attention. Let's dig into the crucial difference between the Indian approach and the English approach to this whole privity thing.
The whole game changes because of one little section in the Indian Contract Act, Section 2D. This section says that consideration, the something for something that makes a contract valid, can come from a third party. This might sound like a tiny technicality, but trust me, it's a massive departure from English law, and it's the key to unlocking the whole Indian position.
This slide breaks it down perfectly. Just look at the two columns. On the left, you have privity of contract. Both India and England agree on this. If you're a stranger to the contract, you can't sue. Simple. But now, look at the right side, privity of consideration. This is where they split. In England, nope, the consideration has to come from the person making the promise. But in India, thanks to Section 2D, a stranger to the consideration absolutely can sue. So the big takeaway is this. In India, you have to be a party to the deal, but the value that makes the deal work can come from someone else entirely.
Theory is one thing, but cases are where the rubber really hits the road. Let's look at two huge cases that just perfectly show the difference between the English and Indian positions we've just been talking about.
First, let's look at the classic English case, Dunlop Tire Co. versus Selfridge. So Dunlop sells tires to a dealer, Do & Co. The dealer promises not to sell them below a certain price. Then, the dealer sells those tires to Selfridge, making Selfridge promise the same thing. But Selfridge breaks the promise and starts selling the tires cheap. Dunlop gets upset and sues Selfridge directly. The court's decision? A hard no. Why? Because Dunlop's contract was with the dealer, not with Selfridge. They were a stranger to that second contract. This case really hammers home that strict black and white rule of privity in English law.
Now, let's flip the script and see the Indian approach in Chennaya versus Ramaya. Here's the story. An old lady gives her property to her daughter, but there's a condition. The daughter has to pay a regular sum of money, an annuity, to her aunt. The daughter agrees, but then stops paying. So the aunt sues her. Now think about it. The consideration for the daughter's promise, the property, came from the mother, not the aunt. But the Indian court said, doesn't matter, the aunt could sue. This case is the perfect real-world example of Section 2D in action. In India, consideration can move from a third party.
Okay, so we've established this really strict rule. But you might be thinking, what about situations where that just seems unfair? Where a contract is clearly made for someone's benefit, but they can't do anything if the promise is broken. Well, you're right. And the law has developed some important workarounds. Let's look at the exceptions, when a third party can enforce a contract.
This really is the critical question, isn't it? If a contract is literally designed to benefit a third person, are they just left out in the cold if things go wrong? Well, thankfully, the answer is no. And this is where the law shows its flexibility, using these powerful exceptions to achieve a just result.
Over time, the courts have carved out these key escape routes from the strict privity rule. The big ones you need to know are when there's a trust or a charge created, in cases of family arrangements or marriage settlements, situations involving acknowledgement or estoppel, and of course, contracts made through an agent. These are the main gateways for a third party to enforce a promise.
Let's start with a trust or charge. The easiest way to think about this is if a contract between two people creates a specific benefit for a third person, the beneficiary. In that case, the law basically says that the beneficiary has a direct right to that benefit and can go to court to get it. The law won't let a technicality get in the way of fairness here.
This one makes a lot of intuitive sense. In things like marriage settlements or family property arrangements, provisions are often made specifically for people who aren't signing the main document. The courts recognize the special nature of these agreements and allow that third-party family member to sue to enforce the promises made for their benefit.
Okay, we've covered a ton of ground. Let's pull all of this together into some quick-fire revision notes to help you structure the perfect exam answer.
This slide right here, this is your blueprint for a high-scoring answer. Seriously, start by defining the basic rule and drop in the Latin maxim to show you know your stuff. Then, immediately pivot to the crucial Indian difference, citing Section 2D. Use Dunlop and Chennai as your evidence to contrast the two systems. Finally, round out your answer by listing the core exceptions to show you see the whole picture. When you think about it, this whole topic is a fantastic story of how the law evolves. It starts with a rigid rule for the sake of certainty, but then carves out nuances and exceptions to make sure justice is actually served. It's a great example of the law trying to be both predictable and fair. Pretty cool, huh?